the statutes and the case law require the DA's office to provide exculpatory information and also information related to an officer's integrity. So if that comes up, that's the first time we're going to be involved in knowing about it. We don't look at a list, we're not involved in the list, and I don't know if we should be, because ultimately we're going to be asked to make a decision about whether that information is relevant. But we don't monitor the Brady list, we don't monitor the process from law enforcement. We get involved once the matter is brought to our attention in a court proceeding. Credibility is really important. As either a judge making fact-finding decisions or a jury making fact-finding decisions, is information that's relevant to someone's, do you think you're credible? Is this witness credible or not? We want to allow the parties to have that requisite information to make sure that the trier of fact, whoever's making those decisions, have the requisite information to make a good decision about how credible is this testimony. Are there underlying things? And they should be brought forward and given us an opportunity to make sure it's fair to everybody involved in the system. I've been a judge for 25 years. Yeah. I was in criminal for, I think, 10 of those years. Never had a Brady issue. Now, that may be that there was one, and then they decided not to call the witness, in which case I would never know because I wasn't part of that decision making.
Is a judge supposed to notify an officer's department if a judge finds their testimony is not credible?
Well, look, you have to understand the context of credibility determinations. It happens all the time in court proceedings. Judges always have to determine what weight they're going to give testimony. And so just because a judge may find that testimony is not credible, and on balance, they determine they're going to make a ruling finding that other testimony was more credible than the latter, that's going to affect their decision, clearly. Does that necessarily mean someone's lying or someone can't testify in another case? We do this all the time. So as a factual matter, judicial officers are constantly making decisions about what weight and credibility to give to a particular witness or evidence. And by that same fact, jurors have the same issue to make credibility determinations. Now, we make the decision about admissibility, but they ultimately will make the decision about how much credibility they feel that testimony or that document has in the proceedings.